Shocking rejection. Predator's plea dismissed as child enticement case heads to trial.
Hold up, did you catch that? This man just turned down a plea deal that could have capped his prison time at 25 years. Instead, he's gambling with his life in front of a jury where the stakes jump up to 40.
A chilling warning for parents. This defendant, facing up to 40 years for child enticement, rejected a plea deal crafted by his lawyer and the DA, leaving Judge Mogen no choice but to push the case to trial, exposing the dangers vulnerable kids face from predators. This must-see case underscores the critical need to protect your children. Tune into this gripping case saga to see the justice unfold and learn vital lessons about safeguarding the innocent.
Can you hear me?
Yes, I can.
All right. We will go on the record in the matter 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt by video conferencing. We have Nicholas Davis, defense counsel, by video conferencing. Christopher Stewart appears in person. We're set today in this matter for a final pretrial. Mr. Davis, can you please update the court? We have a jury trial scheduled for 3 days starting on May 20th. Have the parties been able to reach a resolution?
At this time, we have not, Your Honor, and it is certainly not from a lack of trying. I think I've negotiated on this case more than any case I've ever had.
All right, so it looks like we are going to trial on May 20th for 3 days. What is the offer that's been rejected so I can make...
Quick breakdown for you. A final pre-trial is basically the court's last checkpoint before the real showdown. Think of it as the referee making sure both fighters are ready before the bell rings. No excuses.
Sure that I go on the record and have it officially rejected by Mr. Stewart.
District Attorney will correct me if I'm wrong. Your Honor, I believe it was actually to an amended count of child enticement, order or request a pre-sentence investigation. And if I'm correct, the state was going to cap at the PSI recommendation. And if I'm wrong, I know a district attorney will correct me.
That is correct, Mr. Schmidt?
That's accurate.
All right. And so the child enticement amendment, what class felony would that be? Because we have child enticement sexual contact as class D. So would that bring it down to an E?
No, it's that count. I amended it in when it was rejected.
Okay, so as count 3. All right. And so, Mr. Stewart, the state has made an offer to you to plead to count 3, child enticement sexual contact, a class D felony, and to dismiss and read in the other remaining counts, which would be a class C felony and 2 misdemeanor, two misdemeanors, misdemeanor bail jumps. I need to make sure on the record that you understand the offer and that you're either formally refusing to accept the offer and you wish to proceed to trial, or you are accepting the offer and you wish to set the matter for a plea date. So with regards to the offer is to plead to count 3, child enticement, which would be a class D felony. That would mean that the state would cap at the PSI recommendation, which is a document prepared with a whole lot of information about you, your life, your history, and would have a recommendation for sentencing by a Department of Corrections agent. With regards to count 3, the maximum possible penalty that you could face in this case for the class D could be up to 25 years of incarceration or $100,000 fine. However, with this
40 years Let that sink in. That's an entire lifetime behind bars. Imagine being offered a deal to cut that nearly in half and still saying no. Do you think this is stubborn pride? Or
Deal count 1, which would be a Class C felony, would be dismissed and read in, and that has a maximum possible penalty of 40 years of incarceration with a $100,000 fine, as well as count 2 and 4, which are Class A misdemeanors, would be dismissed and read in, which have 9 months of incarceration or a $10,000 fine. So the agreement, it would be plead to count 3, child enticement, with a maximum possible penalty of no more than 25 years of incarceration, $100,000 fine, with the other matters dismissed and read in. The state to cap at whatever that PSI recommendation is for sentencing. Otherwise, the matter will go to trial, and it will go to the jury for count 1, 2, 3, and 4, with the possible maximum penalty of count 1 being 40 years of prison, $100,000 fine, count 2 being 9 months of jail, $10,000 fine, count 3 being 25 years of prison, $100,000 fine, and count 4 being 9 months of jail, $10,000 fine. So I need to understand, or I need to know if you understand the offer that's been presented, and whether or not you accept or reject the offer that's been extended. Do you understand the offer that's been extended?
Yes, Your Honor.
Now, I need to understand, or do you accept or reject the offer?
I reject the offer, Your Honor.
All right. So he's rejecting the offer. So we are going to go to a jury trial beginning on May 20th for 3-day jury trial with regards to this matter, with maximum possible penalties, if found guilty beyond a reasonable doubt, of maximum of 40 years in prison, 9 months jail, 25 years in prison, and 9 months jail. Again, if found guilty beyond a reasonable doubt. This is the last possible day to have any agreement to be reached. This matter will go to trial. And because these have serious felonies, the court must warn you and provide the warning that when this matter goes to jury trial, and if you...
And here's the kicker. The judge is basically saying, if the jury finds you guilty, don't expect to walk out those courtroom doors. Your bond revoked, straight to custody. This is the justice system's version of checkmate. No safety net once the verdict
are found guilty on those serious felonies. There is a potential, a possibility that the court will revoke your bond immediately after the jury trial, okay? So that is a warning for you to know and be prepared for. Mr. Davis, is there anything you would like to state on the record?
No, Your Honor. I appreciate that you made that record, Your Honor. Thank you. I really appreciate that. Thank you very much.
Thank you. Mr. Schmidt.
There are just 2 things I wanted to cover today so they don't become an issue the day of trial. One, as far as I'm aware, there's not going to be any other acts or rape shield issues coming in because no party has filed anything. I bring that up because in the interviews that were conducted, there's mention of a different sex assault that occurred, mentioned multiple times by multiple people. I also mentioned that second because defense filed an amended witness list today that included Mr. Stewart's mother. My understanding is the mother's being brought to testify to something to the effect that one of the witnesses told her that this was all blown out of proportion and the victim has done this before. To the extent, I don't know what specifically that means because I haven't been given specifics about what the statement is, but to the extent, if that's to mean that the victim has done something before that was negative and affects this case, that would be other acts evidence. If it's referring to something of her sexual history, that would be related to rape shield. So I don't think, if that's what that is, it would come in without motion. and one has not been made. The only other issue I wanted to address today is with that witness in particular, my understanding is that based upon the witness list and discussions with defense counsel, I believe that no investigator was retained to interview that witness, and perhaps that witness was interviewed by Mr. Davis himself. And if that is the case, I'm worried that we're going to go through the state's direct presentation of evidence, a whole day of trial, testimony from the victim, and another child witness. And then we might wind up in a situation where Mr. Davis can't present this witness's testimony without the high potential of either a mistrial or violating ETF 25-01, which talks about when a lawyer becomes a witness in their own case. So I don't know if investigator was present with him. Maybe I'm assuming too much.
All right, so what am I inferring from that? Are you saying that you're looking that a motion may be filed by Mr. Davis, or the fact that a motion was not filed by Mr. Davis?
On the other acts and rape shield, I'm saying none of that's coming in without a motion, not just per the statute, but per the scheduling order. As to the other issue with that, I don't have enough personal information to do any sort of motion related to that. I'm just putting it out there for the court and for Mr. Davis. Like, if that occurred, that's something to be thinking about.
Okay, all right.
Your Honor, I have no intention of other acts. I didn't file a motion because I'm not bringing that in. I think I even had a motion eliminated I think there's an interview. I think there's multiple parties that say the stuff has happened in the past. I don't want that coming in. There are no other acts, so there's no issue there. I have no intention of violating or the rape shield law. And with regard to any witness I have, like any case I've ever had, if I have a witness, I certainly talk to my witnesses and prepare them for trial as best I can. I certainly would never call a witness without knowing what they're going to testify to. I would never have that kind of a witness. But in any event, I don't have any witness that's going to talk about a past occurrence or in other acts. So I don't think that's going to be an issue at all.
Okay, that sounds good. All right, well.
So with no last-minute tricks up either side's sleeve, all roads lead to May 20th, the trial date. 3 days, 4 charges, and 1 life-changing verdict.
We will then see everybody on May 20th, bright and early, 8 a.m.
Thank you.
Thank you very much, Your Honor.
All right, thank you, Mr. Davis. We are